The Second Amendment to the United States Constitution says the right to keep and bear arms shall not be infringed. Well, what does that mean when it comes to restrictions on the right to own and keep guns of felons? Today we'll discuss. Hello and welcome to Talks on Law. I'm Joel Cohen. We're joined remotely by constitutional law scholar, Professor Jake Charles of Pepperdine Law School. Jake, let's talk about felony gun laws.
All right, we got a lot to talk about.
So I guess first off, I teed it up in the intro, shall not be infringed, but then we have all these laws that prohibit felons from owning firearms. How does that work?
Yeah, so one thing we know from the Supreme Court case law is shall not infringed does not mean that every gun law is unconstitutional. So the Supreme Court has said, just like the First Amendment right is not unlimited, so the Second Amendment right is not unlimited. And one specific phrase in the Second Amendment has led to a lot of litigation about this so-called felon prohibitor, and that is the right of the people. And so one question that courts are confronting is who is included in this class of the people? Who would have been understood to be within the people in 1791? Or as one recent court said, who would be understood as to be within the scope of the people today? Maybe we should be looking to today's understanding of the people. But the key question and two theories that have developed around whether or not those with felony convictions can be prohibited from gun possession are one, what's called the civic virtue theory. And this theory says that at the time of the Constitution's ratification, it was understood that those who did not possess civic virtue, those who were lawbreakers, were not included within the class of the people who would have been entitled to possess a gun. That's kind of one theory that says why these restrictions are permissible. Another one that would uphold a narrower class of this classification is based on a dangerousness rationale. And so that rationale says, actually, the common understanding was that those who were dangerous, those who had, for example, committed dangerous felony offenses or dangerous offenses, those people could be disarmed, but not everybody who was a lawbreaker, not those who were breaking the law in nonviolent ways. And so those are kind of the two competing schools of thought about whether or not the Second Amendment permits the disarmament of those with felony convictions. And I should say, the Supreme Court has not taken any cases about who can possess weapons. And so all the hints that we can glean are from statements made in passing in the Supreme Court's major decisions.
So you mentioned laws at the time of the founding. Were there laws that restricted gun ownership from people who had been convicted of crimes?
So there were not in those specific terms. And so what most people do when looking at history is raise the level of abstraction a little bit. And they generally make one of two moves. So one is to say there weren't these statutes disarming people who were convicted of offenses, but there were statutes that disarmed certain groups of people that some say were considered to be dangerous, and that's the reason. So they point to some quite odious laws in the past, like those disarming Native Americans and enslaved Black people, laws disarming Catholics or those who didn't swear loyalty oaths. And they say that shows that legislative determinations about danger could guide decisions on gun possession. And on the other hand, folks say, well, look, at the time of the ratification of the Second Amendment, a felony meant capital punishment. And so if you were convicted of a felony offense, then presumptively the death penalty applied. And so if you could kill somebody for committing a felony offense, then surely you can impose the lesser restraint of taking their guns away. So those are the two moves when folks look to history to say that's the historical tradition that these modern felony laws tap into. But as you suggested, there were not any laws that in these terms prohibited somebody with a felony conviction from possessing guns. Those are a much more modern vintage. It wasn't until the 1930s that we saw laws that prohibited some people with felony convictions from possessing guns, and it wasn't until the 1960s that we get the law in the modern form it is today.
And is that in the 60s where we saw the federal law?
That's right.
Professor, I have to say I'm a little surprised that people will make the argument that, hey, look, we were able to ban slaves from having guns, so as a result, we should be able to ban felons.
Yes, I agree that it's there's something a little bit disheartening about hearing states or hearing judges appeal to these laws in the past to justify restrictions today. On the other hand, this is the test that Bruen seems to demand,
The text, history, and tradition test.
Exactly. And if you're looking to American history to justify gun laws, you're going to find some pretty profoundly ugly things in the American past. And Justice Amy Coney Barrett, when she was a judge on the Seventh Circuit, she appealed to these exact same types of laws to say that what tradition shows is that legislatures could make judgments about who they thought was dangerous. And that's the justification that permits legislatures today to make determinations about who they think are dangerous. Now, we might reject the classifications, say they were wrong in 1791 about who they thought was dangerous and why, but the principle that they regulated based on, dangerousness, is a principle that can be applied to gun laws today.
You mentioned that the Supreme Court hasn't decided to hear a case on this topic, but this is pretty heavily litigated. In fact, felony cases may take a disproportionate share of Second Amendment cases overall.
Absolutely, yeah. It's one of the most litigated, if not the most litigated topic in Second Amendment law, and particularly this provision. It's called 18 U.S.C. 922 G1, the prohibition on those with felony convictions from possessing firearms. And one of the reasons that's most litigated is because the federal government charges lots of people with violating this provision. And so they are all going to raise any kind of colorable legal argument they can in their defense, and this is one that's often raised. And what we saw in the cases is that after the Heller decision, but before Bruen, there were some courts that said, you know what, you're right, that history does not allow the government to prohibit everybody with a felony conviction from possessing guns. Instead, it's only people that have certain types of convictions. So Justice Barrett, when she was a judge, she said, history allows only those with violent convictions, not nonviolent convictions like those with mail fraud convictions or Medicare fraud at issue in that case. Other courts, like the Third Circuit, said, actually, it's a seriousness test. So the government can justify a restriction on someone's gun possession if they were convicted of a serious offense, but not a non-serious offense. And the court there had a multi-factor test for how you determine that, but it wasn't exactly equal to violent offenses. There were serious non-violent offenses that could also justify regulation. One thing that we've seen that's different post-Bruen is that no courts have said that it's unconstitutional to prohibit anybody with a felony conviction from possessing guns. And this might be one small area in which Bruen justifies greater restrictions than did the two-part framework that it replaced.
Why is that, Professor?
If you believe the history that dangerousness or civic virtue was the justifications, then you can justify most of the gun regulations against felony convictions today. Whereas the prior two-part framework said, we're going to look to see if there's evidence that supports these justifications. So if the law is tailored to the interests. There's a classic law review article with the title, "Why Can't Martha Stewart Possess a Gun?" So she had a felony conviction. She can't possess a gun under federal law unless she gets pardoned. And so in a way that it might be really hard for the government to say, what's the evidence that somebody with an insider trading conviction should be barred from firearm possession? There's probably really little evidence that somebody with that kind of conviction is a threat to public safety. But if you're only looking to history and you don't need to justify the law by using modern evidence, then there is some historical evidence that courts can rely on to say, well, even that class of people, they're lawbreakers. There's not civic virtue there. They can be consistently disarmed just like the founding generation would have believed.
So, Professor, where's the law now? What have you seen? What are the trends? Are we seeing more or less movement in the courts?
So we are seeing lots and lots of challenges consistent with the pre-Bruen landscape. One kind of inconsistency is, again, that we're not seeing courts vindicating these challenges. So no courts are saying these laws are unconstitutional, except that right now the Third Circuit entertained one of these cases, and the court said in that case, even Bruen allows states to continue this prohibition as to nonviolent felons. Now that case was vacated, meaning it was wiped away by the full Third Circuit, the full appellate court. And they said, we're going to rehear this case and we're going to decide it as an entire court. Usually the court doesn't do that to agree with what the three-judge panel said. Usually it takes it en banc because it's going to disagree with that. So that case was argued in February, and we're awaiting a decision from the full Third Circuit. And the suggestion might be that the court could say, well, this law is unconstitutional as applied to those with non-violent felony convictions. You can apply it to those with violent felony convictions or violent past, but not to those with non-violent convictions. So that's one case that we're awaiting. Another kind of noteworthy development on a little-known federal law is that there's a law that says if you are under felony indictment, meaning you've been charged with a federal crime, you may not acquire new guns. So you don't have to give up your possession of your current weapons, but you can acquire new guns. That law, no court declared that law unconstitutional after Heller, before Bruen. But so far after Bruen, 4 or 5 lower courts have already said that's unconstitutional. And they've done that based on saying there is no historical tradition of applying these kind of restrictions to those who are charged with a crime but not yet convicted. So I think that's another prime area in which we're likely to see higher appellate court action and then maybe even Supreme Court action because we're seeing inconsistent lower court rulings on that law.
Jake Charles is a constitutional law professor at Pepperdine Law School. Jake, thanks for the time.
Thanks, Joel.